Good morning, everyone. Thank you so much for joining us for the Tech Law Bootcamp, aka TIP Bootcamp. First, I just want to congratulate our students on being done with a year of a law school, whether it's your first year, second year. We don't have any post third years here because I know they have a job to do this summer and I didn't want to bother them while they're starting to study for the bar, which usually happens starting today. So typically our TIP Bootcamp is a day-long series of courses, but for reasons somewhat out of our control, we could not put on a full day of classes today. Our courses on contract drafting, patent law, and our trademark, copyright, and IP licensing class are pre-recorded and available on Box. And we sent out the links to those, but if anybody needs them who's on this call, let me know. And students, so we are also recording this program, and that link will be available shortly. So due to changes in the law since last year, today we are hosting our data privacy course taught by Amy Lawrence, who's counsel to the Privacy and Data Security Group at the law firm Frankfurt, Kernick, Klein and Sells. And before I introduce Amy, I'd just like to give you a little bit of information that will apply to today's bootcamp. First, the Tech Law Bootcamp is free for all Loyola students. If you obtained a summer job through our technology internship program, you are required to view this program as well as the 3 other recorded sessions. Your TIP employers will expect you to have some knowledge in the areas covered by the bootcamp, so please watch the recordings. Anyone who is not required to view all 4 classes may view as many or as few as you like. Please mute your mics, but we'd love it if you could keep your cameras on. It's just more fun that way, but do what you're comfortable with. I will also be attending this class, so if you need to communicate with me for a reason other than asking a question about the substantive presentation, please feel free to use the chat function in Zoom, and you can do that privately to me if you want. If you do have a substantive question, please use the chat function either to Amy or to everyone. You can send your question so that she can repeat the answer and answer the question. Repeat the question and answer it. Finally, this class is, as you know, being recorded. The link will be shared with students as soon as possible. So now I'd like to introduce Amy Lawrence. Posted on the Simplicity in the Events section is Amy's bio. So rather than have me read it and chew up a bunch of time, I encourage you to take a look at it there. Amy, of course, feel free to provide some details about your practice and your experience if you like. So without further ado from me, please give a round of applause and thanks to Amy Lawrence for being here and teaching our data privacy tech law bootcamp class.
Hi, everyone. I'm going to go ahead and share my screen, I think, and see if I can do this correctly. And everybody see my screen?
I don't know if anyone else is having a little trouble hearing you.
I can speak up.
Okay, perfect.
Audio controls being what they are. It's probably easier if I just talk louder. So, hi everyone, I'm Amy, and I am a data security and privacy attorney at a firm called Frankfurt, Kernick, Klein and Sells. I have been working in the area of privacy exclusively for about 4 years, but it's always been part of my practice. I before law school, worked in advertising and worked a lot with consumer data on the collection and use side, and got more and more interested in what we can and cannot do with consumer information on the privacy side. And when I went to law school, I carried that through and started as a litigator, working on deceptive claims and advertising claims litigation, mostly in the class action space, but it dovetailed really nicely into privacy work. And as I got further into my career, I just got deeper and deeper into privacy until it, in the past 5 years, has really exploded as a practice area. There's an option for attorneys who are really looking to drill down into a place where it's a mix of media and IP law, consumer rights, and policy. It's a really fun gray area of the law that is getting darker and darker to black line, and it's a really fun space to be involved in. And so I'm going to try and walk you through some of that. We'll start more big picture with some recent changes in privacy law, particularly in California, but also globally and in individual states. And then and that'll take more of a law school course format. This is what the law says, and this is what we need to do about it. But then we'll talk about what it really means in practice and how we're seeing privacy laws changing that impact on technology that we use every day and the way that the world is communicating online. So, okay, the big picture on privacy is all of privacy laws come down to these fair information practice principles. These 5 areas are transparency, choice, information review and correction. That's the consumer's rights to review their information and correct it if it's wrong. Information protection, that's data security. And accountability, what a company or a business that collects information does with the information that they collect. And so these 5 principles have been cornerstones of privacy law for decades, but it's really very recently that we're seeing them be put into laws. And part of that is because of the growth of the internet and the ability for larger companies to collect more and more information and to process it behind the scenes without consumers really knowing what's happening. So this transparency piece was missing in a lot of circumstances until laws, particularly in Europe, pushed this privacy agenda forward first, and now we're seeing it in the US. So the big topics here in California, the CCPA, California Consumer Privacy Act, was passed in 2018, but became effective in 2012. So that law followed GDPR, which also became effective in 2018, and it really brought consumer privacy rights to the United States in a way that we hadn't seen before. So it drew a lot of, I'm going to see if I can see the chat at the same time. Oh, I can get closer. Yes. Hopefully that helps. Let me know if I need to call or do something different to make it a little bit better. So California passed the California Consumer Privacy Act a few years ago. We're now in a place where we're starting to see enforcement litigation around that. And at the same time, we've also seen a revision to it already. So last year at the ballots, the California Privacy Rights Act, the CPRA, was passed as Proposition 24, and it'll go into effect in the 1st of January 2023. And from there, we'll have one consolidated piece of California legislation around privacy. It's creating sort of a ripple effect throughout the country, and so we're seeing some other states follow with their own legislation, but a lot of those are being proposed and haven't really made it across the finish line, and we'll talk a little bit about that. The impact on technology, the biggest issue that you've probably already seen if you've updated your phone in the past few weeks is that you're now getting a lot more pop-ups, a lot more of these transparent notice and choice pieces of information to let you, the consumer, decide whether you want an app or other technology to be able to collect your information. The death of third-party cookies, this is affecting the way that the whole advertising ecosystem works on the internet and could impact how free the internet is going forward. What we're seeing in sensitive data and inferences is that more and more information is being considered sensitive, and so the ways that companies deal with that information is going to be changing because of the sensitivity of data. And data matching, the way that your information is used, but it's not just the company that you provide it to, but the other companies out there that it's shared with. We'll talk some more about that. And then finally, okay, so I'm going to try and call in after I finish the slide. So on the horizon, we have some more updates, legislation across the country and around the world. And so this is a place where I'm going to pause and see if I can call in and fix my mic.
Hello.
Can you guys hear? Are you good? I think that works.
Okay. I am getting a little echo, so I'm going to try and fix that. Can you still hear me?
Yes.
Okay. Okay. So hopefully that's better. I'm now going through a phone, so you'll see a 310 number pop up, and that's just me at the office. But
Sounds great. Sounds great.
Okay, good. Can we still see my screen? Great. Okay, so the California Consumer Privacy Act, this is sort of where the history of privacy law in California begins. Obviously, it's in the Constitution of the state that individuals have a right to privacy, but there haven't been more specific general omnibus laws around privacy law until we got the California Consumer Privacy Act of 2018. And the way that we got it is thanks or no thanks to Alistair McTaggart, who is the guy that we see here. And the way the story goes is basically that he was at a dinner party with some people from Google who said offhandedly, you wouldn't believe what Google knows about you. And they were talking about, you know, the GDPR coming down the line and the rights that individuals have around their data in other countries. And so the idea that Google has a lot of information about him or you or anyone, the idea that Google has that information, but we can't do anything about it, stuck with him. And so he dug into this issue and made it a personal crusade for him and became the real face of privacy advocacy in California. And so what he did was he took a law that was already written that had been in draft versions in the legislature over the past few years. He just borrowed that and he tried to get it moving again. And the truth is that the legislature didn't have a lot of appetite to move it forward, because the way that it often shakes out is that if you are very privacy consumer friendly, the flip side of that is that it's not very business friendly. That traditionally in the United States, we've looked at data and information collection as a utilitarian pursuit, so that if you are a company and you collect information about your customers, then that's yours. And you can do whatever you want with that as a company within certain, you know, extreme bounds. But for the most part, there wasn't a double check on what companies are doing with data that they collect from their consumers. So with that change in Europe, with the GDPR, letting consumers take absolute control of the data that not just the data that they give to companies, but the way the companies treat that data going forward, that a consumer can always come along and say, you know what, I don't want you to use my data anymore, you have to delete it. That is something that it's fundamentally a different pursuit of privacy in Europe than it is in the United States. In Europe, the individual always owns and controls the data. And in the US, it's whoever has possession of the data that controls it. And so the California Consumer Privacy Act, CCPA, really set out to change that. And without much support in the legislature, Alistair Mactaggart and the co-authors took it to the ballot. And this is, California civics lesson. I didn't grow up in California, so this is all new to me when I moved here. But in California, if you want to pass a law, you can just create a petition, have enough people sign it, and it'll go on the ballot in November. And if it is voted into law, it's very difficult for the legislature to change it. So using that methodology, Mactaggart and co. took the CCPA, they had the petition signed, they got it on the ballot, and once you have something on the ballot in California, like I said, it's very difficult for the legislature to come back and make revisions to it later if it's been passed into law through the ballot process, which is how our tax base right now is sort of locked in place because of the ballot system. And so he was taking that approach with privacy, and the legislature stepped in and said, wait, so that we don't end up with something we can never change, why don't we actually take it up in the legislature? And they got together and they seriously moved forward, and it was passed unanimously within the legislature. Mactaggart removed the ballot measure, and it was signed into law in 2018. It's a very long law. It had a lot of typos. It had other errors and contradictions, a lot of ambiguities. And so the legislature, after it was signed into law, took up amendments. And they fixed some things that were then signed into place by Governor Brown, but it still had a lot of problems. Nonetheless, the law took effect January 1st, 2020, and the idea was that the Attorney General's office is tasked with enforcing it and also with implementing regulations that would help businesses understand what they need to do, how they need to comply with the law. So the law took effect, and then 6 months later, the AG's office had the right to begin enforcement, but then the implementing regulations weren't actually finalized until even later, in August 2020. So there was a huge lag where businesses were trying to figure out how to comply, trying to figure out how to avoid enforcement, and didn't have concrete rules to follow until 6 months ago. So that's where businesses were in implementing the CCPA, and that'll come through a little bit as I talk about it, that a lot of the things that are written in black and white aren't necessarily things that people can agree on. So there are definitions in the CCPA that until August 2020, there were very different viewpoints on what does sell mean. So it says that it means X, Y, and Z, but what does that really mean? What does that mean for me? Is it in my industry? Does it mean the same thing as it means in another industry? There were a lot of open questions like that, and that's why I say that privacy is still a bit of a gray area of the law where you're trying to figure out where exactly enforcement's going to fall. So while that's all happening, enforcement's beginning, the CCPA is in place, the Attorney General is still writing implementing regulations, that at the same time, Mactaggart decided or felt that the CCPA didn't go as far as he really wanted it to. And so he drafted amendments to it. He drafted the CPRA. And this time, instead of going to the legislature to have it passed, this time he went directly to the ballot box. It was a measure that received extraordinary support at the ballot box, prior to the election, at least, it was polling very high. Everybody that you ask in California if they want more privacy, they say yes, which is maybe not surprising to anyone. But then it passed at the ballot, and the CPRA layers over top of the CCPA. It takes the CCPA and sort of turns it up a little bit. It makes some things more specific, some things more clear. The definitions that people were arguing about, it tried to alleviate those disagreements by saying exactly what something is. But it also takes effect in 2 years. So it gives companies a bit of time for that ramp up. But at the same time, companies are in this position where they're supposed to be complying with the CCPA now, and then have to keep in the back of their minds that CPRA will take effect in about 1.5 years. And so there's the push to comply with sort of 2 laws at the same time right now. There's also, the CPRA has this look back provision. So it applies to information collected on or after January 1st, 2022, which basically means that to be compliant with the CPRA, companies should have their internal mechanisms, their procedures in place by the end of this year, 2021. Okay. So the CCPA, CPRA2, has very broad applicability. And I have the bullet points here. It's in any of the above type of threshold, where if you make a certain amount of money, buyers receive or sell a certain amount of information, or derive your annual revenue from selling consumers' personal information. The idea there is to catch data brokers. But the other thresholds were criticized for being very low, that if you buy, sell, collect, receive, or share 50,000 or more pieces of information from a consumer in a year, that's about 137 a day. And when we're talking about consumers, households, or devices, there are, you could collect different pieces of information from the same person on 3 different devices. And so how do you count that? How do you reconcile that with the idea that this was supposed to help people understand their information, but we're still in a place technologically where the business might not know that they might not be able to connect, for example, pieces of information from one device to another and know that it's the same person. So we're still working through some of this. Under the CPRA, some of those criticisms were taken to heart, and the threshold is one place where if a business doesn't meet the revenue threshold, that there will be a higher threshold for the pieces of information that you collect. The idea was to try and cut out small businesses that are maybe, a small brick and mortar store that takes credit cards, and a credit card has your personal information. And if they sell to over 100 people a day, they're probably going to hit that revenue. They're going to hit that information threshold. But the CPRA drills down into what the real concern here is, and has always been, but wasn't necessarily as clear under the CCPA, is the buying, selling, and sharing for cross-contextual behavioral advertising. And so that's a very specific use case that shows up here in the CPRA, which has everything to do with how you are tracked across the internet. Okay, so as far as consumers go, who the law applies to, it's Virginia residents regardless of location, which is one thing that makes it difficult to comply with, because it necessarily means that if a business doesn't know your location, but has an indication that you might be a California resident, so they just have to apply the CCPA or the CPRA across the board. With everybody, all of their customers, they should be treating as California customers. The intent and the effect, really. It also includes some categories of people that weren't normally included in consumer protection law. So we're talking about employees, B2B contacts, vendors, those contacts that you might have in different circumstances where you're not necessarily collecting that person's information to target advertising toward them on another website, but you're collecting their information because you want to pay them, it lumps all of those people together. And it also applies online and offline. This follows, right in line with GDPR and the way that globally privacy laws are trending, is to try and erase this distinction between online and offline, as companies have been better able to erase the distinction between online and offline. Okay, so the personal information that we're talking about, though, is something that can be very broad. And so the information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. A lot of arguments around this, that it could mean anything, that it does mean anything if you have particularly identifying information that it is, combined with. And this was a real sea change in the way that we looked at personal information. It's a conversation that I still have with clients that, in the United States, we used to think of PII, personally identifiable information. It's your bank account, it's your social security number, and that's about it. It's not much more than that. It's some kids' data can get pulled into that, but it's certainly not your email address, your first and last name, and stuff that might appear in the phone book. All of the more general identifying information that we have out there is now considered personal information that needs protection under the law. And the difference that this creates for companies is that while companies would have higher security measures to protect PII, if it's just your financial information that they have to keep secure, that's kind of a small bucket. But if you expand the bucket to everything that you collect about a consumer, requiring a higher level of security protection, then you've really put a much larger burden on companies that are collecting any information from consumers. Okay, in the CPRA, we have a new subcategory of personal information. And here, this is another place where, in response to some criticisms, there's a little bit of an addressing of that in the new legislation. We get this subcategory, sensitive personal information, which is much more like PII. It's your social security number, your driver's license number, your financial account information, your racial or ethnic origin, contents of messages. It gets broader than traditional PII, but it's still things that, that are protected under some other laws or under general confidentiality kinds of obligations that most companies take. The big one that is a change here is precise geolocation, where this is the first time we've really seen geolocation as a piece of information that is protected more specifically. And it comes out of reality and the way that your phone, your device, can track you wherever you are with more and more certainty, and the safety implications of that are out there. And it takes a very broad brush to deal with maybe a narrow problem. But here we get your precise geolocation, which is anything within a quarter of a mile. If you can locate a person that precisely, it is protected information requiring some more security measures. What is not personal information? Information that is de-identified or aggregate. And what that means is, as far as aggregate, if you put a whole group of people together and you no longer see, user 1, user 2, user 3, you see users that like cats, that is aggregated information. But de-identified, CCPA sets out a more stringent standard than we've seen from the FTC and than we've seen from other regulators in the past. So CCPA creates a new de-identification standard that does require more specific, use limitations and restrictions on sharing. What we also have is some added confusion from the CCPA, where we try and categorize the players that are collecting, receiving, sharing information. So the business is the person, the company legal entity that is collecting, that has a relationship with a consumer directly and is collecting their information. Service provider, broadly speaking, is a company that does stuff for the business. But then CCPA introduces third party, which is this category that is defined in a negative by saying, if you're not a business and you're not a service provider, then you're a third party. And then the CPRA adds this fourth category of contractor with a very, very similar definition to that of a service provider. The service provider is processing personal information on behalf of a business, and a contractor has personal information made available to them. But it's unclear right now if it's a distinction without a difference, or if it's actually going to have broader implications going forward. Okay, so as far as what this means as a company, if you're in the legal department, if you're on the business side and you're trying to figure out how to get something through legal, the things that you need to have in your contract to comply with the CCPA are, if you're dealing with a service provider or a third party or a contractor, try and figure out what exactly the vendor is doing for the business. And then from there, you can figure out what contractual restrictions do I need to put in place on them, and what obligations do I need them to put on their vendors. And so this generally means that if you're hiring a vendor and their job is to conduct payment processing for you, then all you want them to do is use the information that you're providing to them to process payments. That they are confined by, the four corners of your contract to only use the information that you've made available to them for a specific purpose and not for anything else, and not to share it with other third parties. If you are actually if you're working on the distinction between a service provider or a contractor, the making available and processing distinction might have a lot to do with hosting and storage and the different type of service that is actually provided by the vendor. If it's a service provider who is actually, processing payments, that's one thing. If it's a vendor like a cloud service provider and they might have access to your information, but in general, they're not really touching it, I think that is the distinction that is attempting to be made there. Contractors under the CPRA have more restrictive use obligations than service providers, even though in general they're both providing a specific service to the business, and the business doesn't want them to use the information for other contracts, other services, but a contractor has more specific requirements around auditing, that they are complying with their obligations under the law, and around the obligations that they have to pass through to further subcontractors, vendors. Service providers also don't have to certify, and contractors do. And the certification is a weird thing under the law, where it's an obligation you have to say in the contract that you understand the restrictions of the law and will comply with them. Now, I will also add that the Attorney General's office has said that they don't think that there's any magic language that they need to see in service provider contracts. But what we've actually seen in enforcement of the CCPA is that they'll still look for it, that if it's a shortcut to saying, yes, this party is a service provider. If you have that language in the agreement, it just makes it clear and easy for everyone. If that language is not there, then there might be some further digging on, okay, so what's the service provider really doing for you? What are they allowed to do with their data, et cetera, et cetera. The business purposes, and service providers and contractors both are constrained. They're only allowed to perform business purposes for a business. And there is a list of things, a finite list of things that are considered business purposes under the law. And this is it here. The big call out is that business purposes include contextual advertising. And so that's where we saw a much bigger conversation in the advertising industry around, well, is advertising more generally a business purpose or not? And lots of questions there that I think are settling, but we'll get to that a little bit later. In the bigger picture, the business purposes are things that you would normally do internally if you had the expertise for it. If you're hiring an outside vendor to detect security incidents and protect against fraud, those are still things that are in your interest as a business, but that you would outsource for the expertise in doing those things. Okay. The consumer rights, these are all, new under US law, rights that are required to be provided to consumers under CCPA and CPRA. In black here, I have the CCPA rights, and in gray, these are the new and different CPRA rights. And I'll also say that in general, the CCPA rights have expanded a bit under CPRA. The CCPA transparency obligations, CCPA really changed the way that companies are writing their privacy policies. It requires a lot more detail into exactly what information you collect, who you share it with, and how you give individuals the rights that we see listed here. So a lot of companies have rewritten their privacy policies. The CPRA, in adding to these rights, will require that again. You'll see even longer privacy policies to provide these, notices of collection and use and access and portability and deletion. How a consumer can actually do these things is all laid out in the privacy policy. So then we get into the actual definitions that have been problematic under the CCPA. And the definition of sell has been a real thorn in the side for a lot of businesses because it doesn't mean just selling. It means selling and renting and disclosing and disseminating and making available and transferring or otherwise transmitting a consumer's personal information for monetary or other valuable considerations. So this was, big news for a long time when the CCPA came out. That sell, if you just read the law and because CCPA requires you to make a statement in your privacy policy, if you don't sell information to other businesses or third parties, then you are supposed to say in your privacy policy, we do not sell consumers' personal information. So sell is this term that became very fraught and heavy for a lot of companies that didn't want to say, yes, we sell your personal information, if actually what they're doing is sharing with another company for a different purpose. So this is where the advertising conversation has really come to a head. If I am sharing your information with another company so that I can target you on a different website, I wouldn't consider that selling because it's not me getting money in exchange for your data. It's me getting access to you in a different place in exchange for your data. And the CCPA expands the definition of sell to include that. But because there was so much conversation around this, the CPRA tried to fix it by saying, okay, so we're gonna talk about sell is what sell is, but we're gonna create this new category of share. And so share, again, targeting directly that cross-contextual behavioral advertising. If I am sharing your information with another company to target you somewhere else, then okay, maybe that's not selling, but that's definitely sharing, and you're gonna have to give the same rights to consumers as you would under sell for share. So we now have under the CPRA, forgive me, it gets confusing. Under the CPRA, you've probably seen on websites a link at the bottom of the page that says, do not sell my personal information. So the revision of that for CPRA will be do not sell/share my personal information. And so it'll sort of combine that to try and make it clear for everybody what's really happening here. this is you'll have to have a link. The alternative to having this link that allows consumers to opt out of the selling or sharing of their personal information is to offer an opt-out preference signal. This is a global do not track that is built into your platform, your browser, that you can go into your settings, you can say, I don't want any tracking, and then the websites are supposed to recognize that and follow it on a broad base. And if they do that, then they wouldn't have to put up a do not sell or do not share my personal information link. We've yet to see in practice an actual global do not track system get off the ground. It's been in the news a lot, especially in the second half of last year, where there is a consortium working on a global do not track mechanism, and there are some big name publishers that have said that they're going to abide by it. I know some of the big browsers that are privacy focused, DuckDuckGo, Mozilla, they're going to abide by it, but it's not in place yet, and so it's something that they'll abide by it when it's there, but it's not completely fleshed out yet. So watch this space. Okay, so what this actually means to you and to anyone who is surfing the web every day, as we all are during this pandemic, is that the internet is about to get less free. If the consumer can say, stop sharing my data for advertising purposes, the reality is that that's how a lot of publishers, and in particular news sources, operate now. That there's not the same focus on your nightly news on ABC, NBC, the major networks. Although those are still there, news sources like newspapers, they don't have the same outlet, they don't have the same reach to consumers that they used to have offline. So a lot of people aren't buying a newspaper anymore, but they might be reading the news through an aggregator like Google News or Apple News, or just going directly to CNN, New York Times, whatever it is. And the way that, I know New York Times has a subscription model, but the way that CNN and a lot of those more national-based news services work is that they just run a ton of ads. They run a ton of ads, and they allow other businesses to target the users of CNN. That's how CNN gets paid whenever a user clicks on an ad for shoes or whatever it is that appears on their website, and CNN stays in business. So there is a lot of hand-wringing about what happens to the news if you allow people to stop sharing their data for advertising purposes. And this is something that's still playing out, and we'll talk more about it when we get to the technological impacts later on. But this is the thing that might change the most in our lifetimes, is how we consume news because of privacy laws. Excuse me. One of the other main things that I want to talk about is under the CCPA and the CPRA, financial incentives. So the carrot to companies that say, well, how am I going to make any money now if I can't collect people's information because they opt out, if I have to let them stop me from sharing their information? The law allows that you can still offer financial incentives and loyalty programs to try and convince consumers to share more information with you. And you see this, there's a lot of it in the retail space in particular of, you can get your loyalty card at your grocery store, you scan it every time you leave. They're collecting information on what you buy, what you didn't buy, so that they can target you with coupons or other promotions or different brands. And then similarly in more of the e-commerce retail space, you'll see a lot of sign up for our email list, get a discount, sign up for a loyalty program, earn points for future discounts. There's that sort of tracking of a consumer's buying habits that can be valuable to retailers to make future determinations about trends, about, more general buying patterns, about what's happening in different parts of the country, to really allow them to make decisions based on past use of their services among their consumer groups that they're servicing. And so the CCPA, everybody loves their airline miles and wants to keep using them. And so the CCPA says specifically, this is still okay, as long as you make sure that you provide the consumers with this additional disclosure of information. What you're doing with that information still has to be upfront for the consumer to say yes or no to. In general, so the, CCPA, CPRA, these are state laws. They're very careful about preemption issues. And so trying to carve out the areas of personal information that are regulated under federal law is something that is very specifically done in not just CCPA, CPRA, but the other state laws that are pending in different legislatures. They will all be very careful to try and avoid overlapping with federal law, to avoid being struck down due to preemption. And here we talk specifically about HIPAA and financial information under the GLBA, but you'll also see this now under as a COPPA, the Children's Online Privacy Protection Act, regulates the collection of information from kids under 13. And not so much in the CCPA, but there's a law that was recently passed in Virginia that is very close to the CCPA, and it is very careful about making sure that it doesn't regulate information that is already regulated by COPPA. But it does extend some protections of COPPA, so that if you are collecting information from kids from 13 to 18, then that's treated as sensitive personal information under this, these subcategories of personal information. As far as enforcement goes, the law allows for civil penalties from the California Attorney General and a private right of action where there is a data breach that impacts non-encrypted or non-redacted personal information. That being said, the actual enforcement that we've seen over the past year plus, it has been minimal. There have been class actions that have cited the CCPA as one of the basis for claims, but they have not been successful for the most part to this point. And a lot of the problems are issues in time, that if there's a data breach and your information is released to the public, to the black web, to the dark web, whatever, if it's out there, then it's only certain pieces of information that you can file a data breach litigation around. And the CCPA doesn't expand that so very much. And while what we thought we'd see is that every data breach that starts a litigation, they would just tack on a CCPA right of action, it hasn't played out so favorably to plaintiffs so far. And part of that is that, if the breach happened before the CCPA was in effect, then you can't use that as the basis for your claim. But it's also that consumers don't always know about data breaches. This is not, this is a place where California does have a data breach registry, but you'll notice that the number of data breaches being listed there dropped dramatically once the CCPA went into effect. And so it's a difficult puzzle right now to see what's really happening in the litigation space around the private right of action, where there's probably been 100 lawsuits that tried it out, and most of them have been mooted, or motion to dismiss has been granted. They're no longer in play. There are a handful that are still moving forward, so this is another watch this space. We'll see what really happens there. As far as civil penalties from the Attorney General, we haven't seen anything publicly yet. There is a lot of enforcement going on anecdotally behind the scenes. The Attorney General sends letters, they start a dialogue with the business and say, you know, you have 30 days to come into compliance with the CCPA. So that is happening in real time, but we won't ever know about a civil penalty enforcement from the CAAG unless it goes to litigation because a company refuses to participate, or because they have they've reached a monetary settlement that needs to be approved by the court. There are only a few instances where we would know about the enforcement, and so this is all to say that it's been very quiet on the enforcement side because it's happening, you know, in a non-public forum. With that said, there's also this cure period that under the CCPA, so that the Attorney General will reach out with a letter saying, bring yourself into compliance by X date, and then a company has the opportunity to do that. Under the CPRA, that 30-day cure period goes away. It's no longer part of the law, and so we'll see if that changes enforcement at that point, if there still will be, you know, more of a dialogue created between companies and the regulators, or not. So then I want to come full circle back to the GDPR, because this is really where a lot of things really started for privacy law globally, and the GDPR was sort of the first domino, which then a lot of other countries around the world have followed in more specific privacy rights, and in particular allowing consumers and individuals the right to contact a company and say that they want to change the way that their information is being processed. So the main principles under GDPR, there's 6 of them, similar to, you know, the information privacy practices that I mentioned at the top, that you will, you know, transparency, that there is purpose limitation around if you collect information from somebody, you're only using it for the thing that you said that you're going to use it for, that you only keep it as long as you need to, that you get rid of it if you don't need it anymore. It's not just sitting in a database somewhere stored, and that you, when you do get rid of it, you do it securely, that you actually make sure that the data is deleted and you don't just stop supporting it in an end-of-life program. The GDPR also sets out these specific bases for processing, and fundamentally, the GDPR is an opt-in regime where everything in the US is opt-out so far. Even the CCPA, it's requiring a lot more transparency, notice, disclosures, but it's still opt-out, that unless you fall into a more narrow category of if you're under 16, if you're dealing with specific categories of sensitive data that a consumer has to opt into. In general, if you're just collecting email addresses and passwords, you're going to still be in an opt-out regime in the US. GDPR is not set up like that. It's always opt-in. It's always, you need the consumer to tell you that it's okay to do what you're doing. And that's often in, you know, in marketing and you know, in the internet more generally, it's consent-based, which is why we have all of these cookie banners everywhere you go, that we use your information to provide you with personalization and to, you know, and to learn about your use of our products and services. So it's a very general, like, yes, that's okay, you can process my data. And then the EU company needs you to say, yes, okay, before they can collect your IP address and use it to target you on another website. But outside of the, you know, the internet, there are a lot of other, maybe more appropriate bases for processing. Very common is legitimate interest, that if you actually need the information to do the thing that you are trying to do, then that's a valid legal ground. Contractual necessity is limited to where the individual is part of the contract. So in thinking about this in a more US perspective, you often have 2 companies contracting for use of a group of individuals' data. And I hear a lot how, like, oh, can't we use like the contractual necessity basis And the answer is no, because the individual isn't a part of that contract. So the contractual necessity is really more like employment. If I give you, my bank account information because I want you to pay me for the work that I've done for the past 2 weeks, that's contractual necessity. Like you can, I won't be able to tell you to delete my bank account information if you need it to pay me. That's what we're talking about there. There are a few other lawful grounds, specific categories around research and, sort of public concerns that there will be, that if you're doing, I want to say public health, given the pandemic, there's so many uses of people's information these days that are justified on grounds of the greater good, basically. Data subjects' rights they are more robust under the GDPR than even CCPA and CPRA even still, because there are these more specific things like restrict processing or object to processing. These allow the individual to really get into the nitty-gritty of what a business is doing and to say, like, actually, no, I don't want you sharing my information with Facebook, but you can still share my information with these other ad-serving networks, and that's okay. In reality, I don't know how often these rights are really capitalized upon, that when someone asks for their information processing to be restricted, I think the more common approach is to restrict it altogether. So instead of allowing the consumer to say that they don't want their information to go to one third party, they just stop sharing the information altogether. The GDPR is also more specific on the bigger picture security and privacy provisions that a company needs to put in place. Things like having a data protection officer are not required under US law. This is somebody whose entire job it is to be the liaison between the individuals whose data the company collects and the decision makers at the company on what they're doing, what the risks are involved with what they're doing with that data, and how they can minimize the risk, what steps they can take, through security measures or anything else to help make sure that the individuals are protected when the company is using that data for the purposes that they want. And the idea of having somebody internally whose job it is to protect the individual's information is very different from what we have in the US, and so this is a position that is in name coming up more often in the US, but the actual role in the EU is a very specific construct of protection of a fundamental right that we just don't have a parallel for in the US. There are also a lot more record-keeping and record-keeping obligations that include things like documenting the processes you went through to make sure that you're following the principles of privacy by design and by default. And these data protection impact assessments are to make sure that when you do roll out a new product or service, you've actually thought about how it could impact individuals, what are the things that could go wrong, what are the things that we can do to prevent that before it ever happens. Okay, when we talk more specifically about the differences between GDPR and CCPA, these will really come into play quite a bit if you're working for a multinational company that is trying to deal with the highest bar, which is often the simplest. As far as privacy protections go, many companies will say, okay, well, we have to do this for GDPR, so let's just do it everywhere. Until it reaches a point where doing it everywhere is actually harder than segregating out EU users from US users and everyone else. And so knowing the pluses and minuses on GDPR and CCPA, CPRA can be helpful when you're trying to make that determination. The biggest part is that as far as applicability goes, I mentioned that CCPA applies to California residents wherever they are. GDPR only applies to individuals in the EU. And so if I go on vacation to Paris while I am in the EU, GDPR protections extend to me. But when I leave, they stay there. So particularly at the beginning, there was a lot of concern around, okay, well, what if I have an EU individual come into my store in Santa Monica? You don't have to worry about it. GDPR is only data subjects in the EU while they're in the EU. The CCPA has that broader, it follows the individual around. And so that's the biggest thing, is that you can apply GDPR much more locally than you can CCPA. As far as the information covered, GDPR and CCPA are similar, but the CCPA and CPRA actually goes a bit further in the information that it protects, partly because of the inclusion of inferences drawn from information that you collect. So it's not just all the information that you collected from somebody. It's if you look at all of that and say, Amy likes dogs, then that piece is also personal information, and that becomes something that you also have to protect. So in that place, CCPA becomes the higher bar that you can apply more globally. This showed up with just weird highlighting. I don't know if you saw that too, but this is, these are some key differences from CCPA to GDPR. As far as layering in CPRA onto this, it's again similar, but a little bit different. As far as the button on the website, CPRA requires the second limit the sharing of my information button, and there's none of that under GDPR. And then as far as enforcement goes, the Attorney General and private right of action apply under CCPA. When we get to CPRA, there's an independent body that will enforce the CPRA. That they've just recently been appointed, and they're forming their board now. Okay, so what do you actually need to do to make all of this happen in a company? You need to know who the players are. You know, if you're working for the company and you're hiring a vendor, or if you're working for the vendor that wants to do work for a company, you need to know who's in charge of the data. And so the controller is the one who determines the purposes and means of processing. The processor does the work. You can be both too. And that's something that is, it complicates things, but it's certainly possible and something to think about. If you collect information and you use it for one sole purpose for the company that you are engaged with, but then you also internally run an algorithm to make your products better, then you might be both a controller and processor. Under the GDPR, controllers and processors need a written contract in place that has very specific requirements. These are all set out in Article 28 of the GDPR, but you have to say, what's the data? How long are you using it for? What are you doing with it? What are the obligations that you have? Are there any flow-throughs? Who's going to comply with the audit? All of those things have to be in writing under the DPA. And so in 2018, it created a flurry of work to try and bring current relationships into compliance with GDPR. And it's something that we see over and over again each time there's new litigation. So under CCPA, there's a push for added language. Under CPRA, we'll see it again for some different language. But this is something that, part of the nature of the beast with privacy law right now is that every time there's a new one, you have to layer in some more language into the written agreement you have. And so it's good to stay on top of what's different and what's the same, so that you can figure out, do I really need to make a change to the agreement or not? So for example, from CCPA to CPRA, slight differences, but if you add in the Virginia CDPA, that law doesn't require really anything different than the CCPA, CPRA. So you can say, well, we're covered already under that law. So for California, I mentioned that the Attorney General is not requiring specific magic language, but they are looking for restricted uses within the agreement. So if the agreement doesn't actually say we'll comply with CCPA, but it does say we'll comply with all applicable laws, you're probably okay with that so long as you also have the use restrictions explained within the agreement at this point. CPRA may be different. Okay, and then as far as actually dealing with consumer requests when they come to you, there are some differences between these. The CCPA is the higher bar because, I'm sorry, the GDPR is of the higher bar because they have a 30-day clock. The CCPA has a 45-day clock that allows you to respond for most requests. The exception to that is the ability to opt out of sale, which under CCPA you have to comply with in 10 days. So there's a lot of information here that I won't read. Just knowing that the GDPR is the slightly higher bar is probably enough there. As far as access requests, sorry, this is an old slide saying that the AG regulations are not yet final because they are final. And it does lay out specifics for the timing of your initial response, saying how you'll respond to a request, and then, how you verify an individual to make sure you're not providing information to somebody who is claiming to be someone they're not. All of those things are there in the finalized regulations. As far as ad tech, and this is I keep coming back to this because I have a background in it, and it looms large in my life. Whether it does in everyone's life, I'm not as positive, but after a year, so we have the ad tech industry is in a place where we could see a lot of upheaval because we're still not figuring out. There are hundreds and hundreds of companies that have not settled on one industry standard. Part of that is because of Google and Facebook, the most powerful players, haven't really engaged with an industry solution in the way that the advertising ecosystem has in the past. So, 10 years ago or more, IAB and DAA were formed really to try and educate consumers around behavioral advertising. It was the point in time when everybody thought that behavioral advertising was creepy, that a shoe ad is going to follow you, from the Zappos website to your news website. And now people are more accustomed to that, I think. I don't think anyone, even if they don't understand why it's happening, they're okay with it happening in a way that 10, 15 years ago, it was more unsettling just because it wasn't part of everyone's everyday life at that point. And so these IAB, DAA, these advertising industry groups, they were formed in part to educate consumers, in part to regulate their own ecosystem so that if there were really bad actors in the space, they could punish them. They could get rid of them without federal legislation. It was all to the point of we don't need a federal regulator because we can handle this on our own. But over many years, there have been more and more players in the ecosystem, and it makes it harder and harder for the industry to create one position point. So what we have now, IAB and DAA. IAB is a lot of the ad tech side of things, and the DAA gets closer to the brand side of things, and they're not always in agreement how to handle an individual's information. We then also have the global privacy control, which brings in, the platform level, the browsers, and maybe it should be something that the ISP deals with. We're getting to a different layer of how we can control the sales portion and the sharing of information among the ecosystem. And then there's always the manual opt-out for anyone that wants to just go it alone. They don't want to be part of an industry group. They don't want to get into a global setting situation. They might decide that they can, they have a small user base and they can manually change the settings for individuals. It's because it hasn't come to a place where everyone agrees. We're seeing more and more splintering, and when that happens, we see more, action from the top. Is I guess how I'll put it. Talk about like Apple and Google making changes to the way that they do business. Cross-border data transfers are the other, major components in how things are going to change over the next few years. We had what was called the Safe Harbor framework for a long time that allowed international businesses to transfer data across borders. And then there was the Schrems case that said that, oh, well, other countries don't have the same protections for individuals, and so we shouldn't be using the Safe Harbor framework. And a court struck that down. So then the European Commission adopted Privacy Shield as a data transfer mechanism specific for the US, where the US, Commerce Department negotiated it, and it became a thing where if a company commits to specific obligations, then we'll open the gates again and cross-border data transfers can flow. That started, it was the new Safe Harbor. And then the Schrems II case, the same person, he, a law student, now lawyer, arguing that the US just fundamentally doesn't provide the same level of protection for individuals that the EU does. And the court agreed and said because of things like FISA and executive orders that allow the government to go to a Microsoft or to another, provider of basically any electronic services. If you've got an email server, you're technically falling under the umbrella of companies that could be contacted for a FISA request. Just the fact that the government could contact those companies to ask for data on individuals who are living in the EU and so have these fundamental rights to protect against that, that was enough that we struck down Privacy Shield. So then, very quickly, Ireland said, Facebook, you got to stop sending EU data to the US. And Facebook challenged that on procedural grounds, but this past week, the highest court agreed and said, no, like this is real. You can't just transfer data to the US because that's where your company is. If it's EU data, then it needs certain protections, and the US isn't providing them. So you have to stop those data transfers. And I mean, it's not just Facebook. Facebook is definitely front and center in this legal issue, but any company that is transferring data across borders is affected by this. And it's created a real question mark around data transfers and what do we do about it, because so much commerce happens in the US and across borders. How do we, as a company, how can we protect data sufficient to, say that we're not going to get in trouble with the EU, they're not going to shut off our data flows? And there are a few other alternative transfer mechanisms. The main one that gets most attention is model clauses, controller to controller and controller to processor. These are agreements that can't be revised. They have to be agreed to as is. That would allow a company to say, we offer a certain level of protection, and so you're okay transferring data to us. The controller, they're currently in the process of updating because they're about 10 years old now, I think, maybe older. And so fingers crossed. I mean, I heard that they were going to come out in January, and then they were going to come out in March, and here we are in May, and they're still not out yet. But hopefully this year we'll have new controller to processor model clauses that companies can agree on. In the meantime, they're using these older model clauses and adding what we're calling supplemental measures, which is, the European Commission has looked at these outdated controller processor model clauses and said, well, here are some things that you could also do on top of this that would help that. So there are some things, and there are companies that will ask their vendors, okay, so we can do model clauses, but what else are you going to do? What are your supplemental measures to make sure that basically, if there's a backdoor to the U.S. government, are you going to tell us about it, or how are you going to prevent it to keep our EU data safe? There's also binding corporate rules. These are more often, within a large corporation, if you're operating across borders, to say, like a Microsoft that has offices around the world, how can they share data with their other offices in other parts of the world? That's normally where we see binding corporate rules come into play. Okay, that's kind of the big, buried legal picture on privacy law in the world right now. CCPA and GDPR are taking center stage, CPRA ready to enter stage left, and other states also having a few, solos coming up in the next few years. But right now, we're seeing a lot of different things on the internet, and so this is how it really plays out. I want to go through, in general, just sort of the baseline, the different types of advertising that you're seeing. I don't know if this will be helpful or if this will be, I don't know, a bit rudimentary for some of you, but it helps me sort of set the stage for, like, this is what we have right now, and this is how it'll change. So the first thing I want to just explain is contextual ads, and this is the thing that is allowed for in the CCPA as a business purpose. And this is basically when you allow for, search results. If I put in Ford in Google and the first couple of things come up, and they're based directly on what I have entered into that website, then that's contextual advertising. The other way that this comes up is that if you go to a website and the advertising that you are exposed to there is based upon the content of the website. So if you go to a website for, like, Yosemite National Park, and the ads that you see are for hotels around the park, something like that, whereas they're advertising to you because of what's on the page or what you have entered into the page. It's contextual because it's based on a piece of information that they already have from that immediate interaction. Interest-based ads come up when we know information, when a business knows information from a prior interaction with you. So if you go to the Ford website and then you continue surfing online and you start seeing Ford ads on other sites, that is behavioral-based advertising, because you've visited the site, so we know that you're interested, and so we're trying to stay with you throughout your journey. So it can be, in your browser, you go to a different site, you see the ad. Part of this is, and this was some of the industry resolution that came out a decade ago, was providing the enhanced notice. The way that the advertising industry and the ecosystem tried to explain this to consumers was, your ad showed up on a new site because of information we have about you, but you can always turn it off if you want to. So you just have to look for this little triangle and then click on it, and we'll take you to our privacy policy, which says exactly what we do, how we got this information, and how you can opt out of it. So this was it's all built in to try and make consumers more comfortable with the fact that they're being followed across the internet. You'll also see this across, your phone. If you go to, it's the same idea that if you're F4 and then you go to a new website, you'll still see the same opt-out, the same notification, where you'll see that it is sponsored content. It's all because of an attempt to try and make consumers aware that this is how we got your information. And it's all happening for a reason. It's not completely untransparent and something that is bad for you. It is something that if you don't want it to happen, you can turn it off. The way that it happens is through the use of identifiers. And so the way to follow someone from one website to another has historically been cookies. And the cookie will record your device identifier, your IP address or MAC address. It'll also have, if you've opted out, that information might be there. It'll have device ID, time and date stamp. All of those things would be information that would be stored in a cookie and then used later on to target an ad to your device at a different time and place. The other way that this information, the identifiers are shared and stored, is when you actually log in to a website. So if you enter your username and password, obviously ESPN or whatever site you're logging into knows it's you. There have also been a lot of single sign-on solutions that have come up that allow you to use a third party that might have a lot more information on you, like Facebook or Google. And if you use one of those third parties to sign in, then not only does the site that you're signing into get the benefit of some more robust information from that third party, but the third party also gets the benefit of the information that you're sharing with that individual business. So then you'll see it if you've gone through a single sign-on, or if you have used a service that can connect cookies across devices, then you'll have a situation where you're looking on your laptop at cars, and then later when you're on your phone, you might see an ad for something that you looked at on your laptop because of these connections through cookies or through single sign-on and first-party data. Okay, the way that this also can play out, and this is becoming strangely popular, I don't feel like everything that I see on Instagram I get mail about now. And so there's that aspect where you're online or you're in an app and you're viewing, you see something or you view an ad, and then later you also get something at your home. It's because of there are services that connect all the dots to be able to say, okay, user 1234 in this cookie lives at 2029 Century Park East, and so we'll send them an ad there too. The whole idea of notice and choice, though, has been lost on a lot of people in the world that we are currently living in. That the idea that you would allow a company specifically to use your data isn't something that people think too much about, and it became something that then the app stores were pushing, and Apple in particular started this and is continuing this push where instead of an opt-out, let's get ahead of it, let's get people to actually consent to it. And so that started a few years ago when you started seeing the can I access your location type of pop-up, that always, sometimes, never. And it really came out of these type of enforcement actions where the FTC and state attorney generals and city attorney generals were accusing companies of using information in a way that is deceptive because it was never explicitly revealed to individuals. And so So now Apple has, you know, captured that and said, well, we'll force that now as where we're going. So we see which way the winds are blowing, and if companies aren't going to do it themselves, we're going to force that. And also we're going to allow our individual users to say, you know what, big picture, I want to limit the ad tracking. I don't want my apps, I don't want the SDKs in my apps to be using my information unless I say okay. We've seen that push over the past couple of years. This is just more of, you know, and we have the notice and choice, you'll see it everywhere now, the little icon. And I think I might actually have some repeat slides in here, so we'll speed up a little bit. So the reason why I really stuck down on this and advertising has been a big part of my practice and a growing part of my practice because it is a huge ecosystem. There is just, you know, every company is spending money on digital advertising these days in a way that I don't know, maybe every company always spent money on advertising, but it is now funneled directly into digital advertising. And that's only accelerated over the past year because the pandemic has forced everyone to spend their life online. And so a couple of years ago, digital advertising for the first time beat out traditional media spend, you know, by a little bit. But this year, it's already taken, fully eclipsed. We are now, digital advertising spend is 2/3 of media spend. It's not half, or, you know, it was anticipated that it would be, you know, 6%, 7% each year. It would gradually, you know, become the majority, but now it happened in about a year. We very quickly moved to a place where much more money is spent online because so many more people spend their time online. There are a couple of ways that digital advertising is bought, and so the money is going into a few different channels, and it can be bought directly. So if I know that you are a Ford shopper and you are also a sports fan, then I will, as Ford, contact ESPN directly and say, I want to buy eyeballs on your website, and that's a direct buy. But more and more of it is programmatically, which is more of an auction situation. We can drill down into a little bit more about what that means. But as its baseline, it means that it's based on the data that's been collected about you as a website traveler, and the information, the database and profile that's been built about you based on your viewing activity. And so this is where I first started on this. So your direct buying would be, I want to place an ad directly onto this station because I know that people are watching sports right now. I know that, you know, the Super Bowl captures everybody in America, and that's why the advertising rates are so high during that one media event. And so, but that's a direct buy. I want my ad to be shown during the Super Bowl. Programmatically is real-time bidding through algorithms, and the data that is layered based on budget, audience, and brand safety. These are all things that are calculated instantaneously based on enormous databases of data built up over time from individual users. And so who does all the data collection? It's all of these companies, hundreds of companies that, you know, that have different roles there. As you get, you know, from left to right, you get closer to the individual who's actually surfing the web. On the very left side, the marketer, this is the brand or the advertiser who, you know, hires an ad agency, who works with a trading desk, who works with a supply side buyer, and then, you know, it goes to an exchange. In the middle, you have the exchange. That's sort of the halfway point where the exchange sort of takes, okay, I've got an ad and I've got all of these different websites that need ads to make money. how do I make the connection? And then from there, you do as much targeting as you can based on the data that you have. You factor in, social tools that you might have. What sort of information does Facebook have on this? Are they the best place to publish this data, publish this ad? Because we know that everyone's going to be on Facebook at some point, and it's just a matter of timing. And then, is that the best way to actually get in front of a person? It is vast, and there are some companies that do very, very specific pieces of this, and then there are some companies that take on a bigger role because they work in maybe 2 or 3 different buckets. We're seeing that more and more. So when you're buying programmatically, this is just kind of another way to look at it. The marketer, it goes to the ad server, the trading desk. This DMP is just pouring data in to try and figure out how best to reach a certain category of people or a certain demographic. What's the best site to reach them on? The ad exchange will take all of the sites and all of the data about the audience and determine where the best place to serve the ad is, where the highest bidder is. The consolidation around this is because the more data that any one of these players has, the less it's spending across the ecosystem. So if I don't have to hire an agency and a DSP and an ad network, then that's savings that I can realize. So what we're seeing is consolidation to allow for that. It doesn't mean that, for the brand, it doesn't mean advertising prices are going to go down. It just means that there's going to be larger capture at certain spots in the ecosystem. And then the final layer on this that I'll add is that data matching becomes much more valuable, because so I have a whole database about your surfing history, your buying history on my website, your interests that you have let me know about, because when I see your cookie data move across time, I know what other websites you visited, that sort of thing. But I still only have my window into your activity across the web. And if I can get somebody else's window and combine them, then I know twice as much about you. And if I know twice as much about you, then I might be able to reach you faster, easier, cheaper. And so data matching has become, a normal and important part of the advertising ecosystem, where I can say, okay, I have a brand. I know that my values closely align with this other brand's values. And so my brand and that other brand, let's see where our overlap of customers is. And then we can use that information of overlap to target not just those people, but people like those people. So I can take that audience that I've created of my users and my ad partners' users, go to Facebook and say, target not just these people that like dogs and skiing, but find me other people that also like dogs and skiing and serve the ad to them too, because they might be good connections for me to make with my brand and with this other partner brand. And so then you have to layer on top of that, if okay, so I have my custom audience that I built with another brand, but I might also want, some more information about the people who are in that audience. So there are these data brokers, there are vendors out there that specialize in a portfolio of information about individuals. And so that's, Experian, we also know them as a credit reporting agency, but the truth is they have information on your purchase history as far back as your credit history or your employment history. And so if I know about, there's somebody that likes dogs and skiing and likes my product, And then I can go and layer in other information about that person, what else they like to buy, and that might also let me know where I can reach them. If I know that okay, so you like dogs and skiing and you also shop at IKEA a lot, then maybe I can use that to target people that like IKEA when I'm looking at targeting an audience on Facebook or another social network. So the regulation of all this has largely fallen to the Federal Trade Commission and state attorneys general. The industry self-regulation of this has been mostly to regulate the interactions between the players in the ecosystem, so that if you're a member of the IAB and you have a contractual dispute with another member of the IAB, and you're using the IAB terms that are suggested, then you can take it up with their enforcement agencies, with their enforcement bodies, or you can take it to the Better Business Bureau, and you can privately, or at least it's not public, there are dispute resolution resources out there for industry self-regulation. But as far as the consumer goes, the regulation is really more at the state and federal consumer protection level. And so one of the ways I include this is a COPPA flag. One of the things that we're seeing play out is that there's a more robust requirement for players in the ecosystem to be able to communicate with other players in the ecosystem about the data that they have and that they are willing to share, and that the consumer is okay with sharing. So this comes down to when you're offering the CCPA opt-out of sale, how do you communicate that with all of the players in the ecosystem? And the technical solution is to flag it in a way that it becomes the publisher, the one that has the connection with the consumer, becomes their responsibility to sort of start the dominoes. And the way to start it is by flagging the code that you're passing along with data to say that, okay, so this person, if my website is directed to children, then I need to put up a COPPA flag so that everybody that receives data from this website knows that it might be a kid. If the individual who visited my website clicked the do not sell button, then I want to make sure that that is part of my string, and so that everybody that receives this data knows that this person clicked do not sell my data. Anecdotally, putting this into place, because it's an opt-out regime, it hasn't made too much of a difference in monetization, because in the US, at least so far, consumers aren't really clicking those do not sell my personal information buttons at a really high rate. There's a lot of varying, but it's not the end of the world that I think a lot of the ecosystem was really worried about. There hasn't been a steep drop off in that when you make it an opt-out. They're around, it gets more broad than just the string and making sure that individuals, opt-outs are passed along. We've seen a lot of FTC action and some at the state AG level around privacy protection very generally. And whether it is a failure to disclose that you've shared information with a third party, like the Zoom lawsuits, that they were sharing information with Facebook without everybody knowing, and suddenly everybody was using Zoom all the time, including us, and how and they didn't know that their information was also being shared to some extent with Facebook. So there's that type of action. The failure to opt out is that if you just ignore your obligations to allow consumers to to say that they don't want you tracking them, or that they don't want you to sell their information. Or even if you have an opt-out button and it doesn't work, which I think was also one of these, that those are things that you've now deceived the consumer. If you have said that you would provide an opt-out and it doesn't actually work, or you don't actually provide it, then that is that's consumer deception, and that's illegal. It has been illegal forever. It's not just an internet privacy thing. It is, you can't do that to consumers legally. Location information, there are more specific requirements around geolocation. Even before this CCPA, if you were sharing information after saying that you wouldn't, again, it's deceptive, and those are things that regulators don't want you to be doing. As far as COPPA, it's worth noting that the content creator shares the responsibility of any downstream recipient of data, and this is something that is also part of the big change at YouTube over the past couple of years, where now content creators have to let YouTube know if their content is directed to children, so that YouTube can on the back end say, okay, this is what we do with that data, because we can't do certain things with kids' data. On the horizon, we have big picture changes from the top down. So Google announced that they won't use cookies anymore. And this was, it's brought on by the opt-in requirements in the EU. And also there's some proposed legislation in the EU that recommends, at least, it's called the Digital Services Act, and the idea is that it would phase out any use of cookies for third-party advertising, and that it would phase out, behavioral advertising. Because a lot of that behavioral advertising is built on identifiers that are stored in cookies, Google decided that it would no longer support cookies, third-party cookies. And so in response to that, they also said, but we're going to build something new. And they created a privacy sandbox where there actually are a lot of participants in the ecosystem trying to think of ways that we can still do targeted advertising in a way that is more privacy friendly, so that maybe you don't have to know that an individual, you don't have to know, 10 years of buying history to target an individual so specifically. You might just need to know the overlap of they like dogs and skiing, and you can do something more contextual or more demographically based than something so very specific as, oh, well, you went to the Ford website, so now you're going to see a Ford ad. So they've created the privacy sandbox. There are players in it. It's very much a watch this space, because it seems like the leading contender right now is something called flocks, which is basically just groups of consumers instead of individuals. So, if you like dogs and skiing, then you're in the dogs and skiing group. And there are hundreds of people that also like dogs and skiing, and they might not also, own 2 dogs and, rent ski equipment. It doesn't get as specific as that. It's more general interest based. The other big thing that is also more recent, and this is, it started with the Apple side, and I think Google will catch up pretty quickly. So if you've recently updated your iOS, you might have noticed that the new privacy features in the App Store require several things of app providers. And the first was a nutrition label. And so you have to, app providers are now required to describe how they use their data, and it comes to consumers in this chart of data that the app collects, data that they link to you in a profile, and then if they share it more generally to third parties like SDKs that are embedded into the app. So that started a few months ago, maybe. I think that there might have been companies that were trying to get ahead of it before it actually became a requirement. The difficulty for companies here is that now, okay, so you already have a privacy policy that you gave to Apple, but now you have to create this Apple-specific nutrition label of privacy that doesn't necessarily line up with your legal obligations in how you describe data collection. And so there's some concern that that reading this nutrition label, while it is simple and streamlined, it doesn't provide you as much information as if you went to the privacy policy. And so is there something inherently confusing for the consumer there if you're saying slightly different things in your nutrition label and your privacy policy? And we don't have regulators weighing in on this yet, and we might be years away from that. So it's it's something that companies are grappling with right now, how to make sure that they're complying with their obligations under their App Store agreement, but also their legal obligations under the CCPA. The second big part of this was that after the nutrition labels went into effect, and the next update was the asking permission to track. And so any new app, you're going to get a pop-up unless you've set your global settings in your device to say don't ever allow tracking, and then you won't even see these pop-ups. But if you allow that, these pop-ups will come, and the company this is their 5-second ad on how to convince you to allow them to track you across apps and websites, which is how they make money when they're offering you a free app, by allowing ads to appear within their app, and then also sharing information with other apps to create targeted advertising. So the early returns on this have been, the word devastating has come up more than once, that something like, more than 90% of people are not allowing app tracking, and that is in a way that the CCPA hasn't had the dramatic monetary impact. This move by Apple to require an opt-in is having a dramatic effect, and that to bring us full circle, this is the difference between an opt-in regime and an opt-out regime, and GDPR requiring an opt-in regime seems to be more protective of the individual. CCPA with an opt-out regime may be less protective of an individual overall, but still allowing business to monetize information that they've collected in a very American way. And so then Apple comes in with this opt-in regime and turns the whole thing on its head. So while U.S. companies had, for the most part in the U.S., escaped the impact of the monetary impact of GDPR, and CCPA maybe hasn't yet come to a place where it's had a huge impact. This, in the private sector, this change by Apple can and seems to be having a much bigger effect. This is more of how how you're seeing these pop-ups and the things that companies are saying, because they really are trying to convince you to allow them to help keep Instagram free of charge. And this is their one chance to convince a consumer to let us keep using your information, because once you say no, if you don't opt in, then at least at this point, there isn't really a mechanism for them to ask you again at a later date, unless you remove the app and download again. And then, the other big piece of this that's happening in the background is the antitrust aspect of everything. That there are legal battles going on, in the private sector in the U.S. between Apple and Fortnite around what's happening with the App Store and their control of that. And in the EU, I mean, cynics have always said that GDPR was really about antitrust and the fact that all of these big tech companies are US companies and the EU can't compete with that now that all of the data is already in the hands of these big tech companies. So how do you regulate that once you know, the cat's out of the bag, so to speak? Like, they already have all the data. It's hard to combat that unless you take the position that it's anti-competitive and they need to be broken up. And so there's that part of it that I think that you'll see more and more of over the coming months and years. And I will say, so Apple has been on the front lines of this in you know, a lot of scenarios, particularly in the U.S. and the nutrition label for privacy and the app tracking. But Google's App Store recently announced that they are also going to require a similar nutrition label, and you know, they haven't yet required this opt-in to tracking, but I think that it's not crazy to think that they will follow to so that you have sort of, again, the duopoly controlling the system as on the app side of things and collection of data there. And I think, yeah, that's all I have. I feel like I spoke nonstop for the past couple of hours, so if there are questions, I'm happy to take them, but I also realize that this can be a lot to digest, and I won't be offended if there aren't questions, so feel free to jump in.
Does anybody want to ask? Oh, Mark, would you like to ask your question?
Sure, thanks. Thanks, Ms. Lawrence, for the presentation. Yeah, it is a lot of information, a lot of really good information. You know, for the for basically these boot camps, it's a lot of preparation for people going into tech positions. And I was just kind of wondering, you know, given the landscape, what are some of the kind of tasks that maybe some students over the summer might be you know, tasked with doing that would kind of you know, fall into this subject area?
Yeah, it's a great question. So at least at my firm, what we have summer associates do when we have them, you know, when there's not a pandemic, is that they will be, you know, the first drafters of things like privacy policies and pop-up notices and things that are really consumer facing. So that requires an understanding of the company's use of data and how they want to present that to a consumer. So, you know, in these Apple requests for tracking, you're seeing them, you know, they started pretty stoic, and they're getting a little bit, you know, they're getting a little cuter of like, this is, you know, keep our app awesome, stuff like that. So it's part data transparency, it's part marketing, and it all comes down to understanding not just what your company, your client, what they're doing, which is the big part of it, figuring out, doing the drill down, the real thinking about, okay, what information are we collecting? What do we need to say we're collecting? Which can be a huge fact gathering project that you would be involved in. And then from there, distilling that into a consumer-friendly narrative about, you know, whether that's in the privacy policy or in these pop-ups, notices, that frontline, you know, even banner communication with the consumer, being able to, particularly as somebody who is maybe younger than everybody else that you're working with and is probably more familiar with all of the technology that you're working with, being able to distill a lot of data into a consumer-friendly narrative, I think that is something that is going to be really valuable in you know, in working over the summer with these companies and being able to be that bridge that they need when they say, okay, so they've got the whole front half of the presentation down. They might know CCPA backward and forward, but actually implementing it, having tech savvy young people around is super valuable. And if you can like pull those strings together, that's something that I think is something that you'll use over and over again.
I should unmute. Ethan, go ahead.
Thanks. Thank you for the presentation. I was wondering, I can see how like big tech companies like, Apple, Google have a big hand in privacy related things, but I also heard that basically even like retail companies, anyone who's on the internet and has some kind of, basically is on the internet and advertising in some way is going to be affected. And so I was just wondering, in terms of us developing as professionals, is data privacy going to be like part of our practice when we're in like the, I don't know, the technology, whatever technology section of a firm, or could it be our whole practice? What do you think about that?
Yeah, it can be your whole practice. It is my whole practice, but it wasn't always, and it's in part, where you end up. If you end up in a large firm doing corporate work in a tech transactions capability, then the privacy parts of it, might only be one section of an agreement you're working on, or one due diligence assignment. It might be one aspect of a bigger picture that you're working on. But if you end up in a company that is processing a lot of consumer data as their monetization model, then the privacy implications are front and center all the time in agreements with vendors, with customers, with the App Store, with hosting providers. It really depends on where you end up. If you're in a consumer-facing company that processes a lot of data, it'll be a bigger piece than if you're in a group that has a more of a corporate focus, or even an M&A focus. It'll come up, but it won't be all day every day. So it could be all day every day if you want it to be. It just doesn't have to be.
Got it. Thank you.
Anybody else want to ask? Well, we're sort of ending right on time. It's 2 minutes to 12. Okay, well, if there are no other questions, I want to echo students' thanks to Amy Lawrence for providing this amazing class on a Monday morning.